Before we begin, a quick and important disclaimer. This video is intended strictly for educational and entertainment purposes and does not constitute legal, financial, or tax advice. The division of retirement assets, specifically 401k accounts during a divorce, is governed by complex federal and state laws that vary significantly by jurisdiction. Any case studies or historical trends discussed are for illustrative purposes and do not represent a potential outcome for your specific situation. We strongly urge you to conduct your own due diligence and consult with a qualified family law attorney or a certified financial planner before making any decisions regarding your marital assets. Imagine you have spent 25 years meticulously building a fortress. Every paycheck, you sacrifice the immediate gratification of a new car or a lavish vacation to divert funds into your 401k. You watch that balance climb from 4 figures to 6, or perhaps 7, weathering market crashes and economic shifts. Then, in a single legal proceeding, half of that fortress is dismantled and handed over to the person you are currently sitting across from in a mediation room. In the United States, the 401k has become the primary vehicle for retirement for millions of workers, but it has also become one of the most volatile battlegrounds in modern matrimonial law. We are currently living through a period where retirement assets often dwarf the value of the primary residence. Yet many Americans are walking into divorce court completely unaware that their biggest financial safety net is legally considered a shared asset. This isn't just about losing money. It is about the structural shift in how 21st century wealth is defined and then divided. If you think your premarital contributions are safe, or that your spouse can't touch the gains you made during the marriage, you are operating on outdated assumptions that could cost you decades of security. Today, we are solving the most pressing financial mystery of the modern American divorce: how to protect the integrity of your retirement while navigating the rigid machinery of federal law. This masterclass will provide you with the historical context of how 401k division evolved, the granular details of the legal instruments used to split these accounts, and the specific data points you need to understand to avoid devastating tax penalties. By the end of this deep dive, you will understand the intersection of the Internal Revenue Code and Family Court in a way that most people only learn through expensive, painful experience. To understand where we are in the 21st century, we have to look at the massive shift from defined benefit plans to defined contribution plans. In the mid-20th century, most American workers relied on pensions. These were defined benefit plans where the employer bore the investment risk. When a couple divorced, the pension was a future promise of a monthly check. Fast forward to the current era, and the 401k, a defined contribution plan, reigns supreme. This shift transferred the risk from the employer to the individual, and in the process, it turned retirement accounts into liquid pots of gold that are ripe for division during a domestic dispute. The first concept we must master is the distinction between marital property and separate property. In many U.S. jurisdictions, any contributions made to a 401k from the date of the wedding to the date of legal separation, or the filing of the divorce petition, are considered marital property. It does not matter whose name is on the account. It does not matter who earned the salary. If the money was earned during the marriage, the law generally views it as a joint effort. However, the complexity arises when we look at the growth of those funds. Historical trends in U.S. case law show a shift toward active versus passive appreciation. If your 401k was worth $100,000 on the day you got married and $500,000 on the day you divorced, calculating exactly how much of that $400,000 gain is yours alone requires a forensic level of accounting. Let's look at a case study involving a mid-career professional in a community property state like California or Texas. In these states, the law typically presumes a 50-50 split of all assets acquired during the marriage. If this professional entered the marriage with a robust 401k, they must provide tracing evidence. Tracing is the process of proving through historical statements that the initial seed money remains separate. But here is the catch. If they took a loan from that 401k during the marriage to pay for a down payment on a marital home, or if they rolled over an old 401k into a new one while married, they may have commingled those assets. Commingling is the legal term for mixing separate and marital funds to the point where they can no longer be distinguished. Once an asset is commingled, the court may rule that the entire account has been transmuted into marital property. This is a trap that catches thousands of people every year. Beyond the simple division of the balance, we must discuss the legal mechanism that makes this possible: the Qualified Domestic Relations Order, or QDRO. You cannot simply log into your Vanguard or Fidelity account and wire half the money to your ex-spouse. Doing so would trigger an immediate 10% early withdrawal penalty from the IRS if you are under age 59.5, plus ordinary income tax on the entire amount. To avoid this, the U.S. legal system uses the QDRO. A QDRO is a specialized court order that instructs the plan administrator of the 401k to carve out a specific portion of the account for the alternate payee, the ex-spouse. The historical significance of the QDRO cannot be overstated. It was established under the Retirement Equity Act of 1984 to protect the interests of non-earning spouses. In the 21st century, however, it has become a logistical nightmare for the unprepared. Each 401k plan administrator has their own specific requirements for how a QDRO must be drafted. If a single word is out of place, the administrator can reject the order, sending you back to court and costing thousands in additional legal fees. Furthermore, the timing of the QDRO is critical. If the account holder retires or dies before the QDRO is finalized and served to the plan administrator, the ex-spouse could potentially lose their claim to the funds entirely. Data from recent decades suggest that the average 401k balance for individuals aged 55 to 64 is approximately $200,000 to $250,000, though the median is often much lower. When this is divided in a divorce, both parties find themselves with a significantly diminished safety net. This leads to what sociologists call the gray divorce phenomenon, where individuals over 50 are divorcing at record rates. For this demographic, the division of a 401k isn't just a line item on a spreadsheet. It is a direct threat to their ability to stop working. They do not have the 20 or 30 years required to rebuild that fortress. Another layer of this deep dive is the tax implication of the division. When a 401k is split via QDRO, the recipient has choices. They can roll their share into their own traditional IRA, which defers taxes until they retire. Or they can take a cash distribution. Under current IRS rules, a distribution made to an alternate payee pursuant to a QDRO is exempt from the 10% early withdrawal penalty, even if the recipient is under age 59.5. However, the distribution is still subject to mandatory 20% federal income tax withholding. For many, this is a tempting way to get quick cash to start a new life, but it can be a devastating long-term mistake. By taking the cash now, they lose the power of compound interest that would have accumulated over the next decade. In the next sections of this masterclass, we will break down the specific math of coverture fractions used to determine marital portions, the risks of 401k loans during a divorce, and how to negotiate offsets, where one spouse keeps the house and the other keeps the retirement. Understanding these details is the difference between a secure future and a total financial reset. We are looking at the 401k not just as an account, but as the most significant legal and financial hurdle of the modern era. To navigate the 401k landscape in 2026, we must first master the mathematical engine that drives asset division, the Majowski's formula, often referred to in modern legal circles as the coverture fraction. Imagine a professional named Michael who began working for a major aerospace firm in Seattle in 2010. He started his 401k that same year. In 2016, he married Sarah. By the time they decided to file for divorce in early 2026, Michael had been participating in the plan for 16 years, but only 10 of those years occurred during the marriage. Many people mistakenly believe that the court simply looks at the account balance on the day of the wedding and subtracts it from the balance on the day of the filing. This is a dangerous oversimplification. Historical trends show that courts increasingly favor the coverture fraction to determine what is marital and what is separate. The numerator of this fraction is the total months of participation in the plan during the marriage, and the denominator is the total months of participation in the plan up to the date of the divorce. In Michael's case, his numerator would be 120 months of marital participation, and his denominator would be 192 months of total participation. This creates a percentage that represents the marital portion of the total asset. If the total 401k is worth $500,000, only a specific percentage of that total is subject to a 50-50th split. But here is where the complexity deepens. What happens to the market gains on the premarital portion? If the initial $100,000 Michael had before the wedding grew to $200,000 purely through market performance without any new contributions, is that growth marital or separate? In 21st century U.S. history, different states have radically different answers to this question. In some jurisdictions, the passive appreciation on separate property remains separate property. In others, the moment you use marital funds, your salary, to contribute to that same account, You have created a commingled asset where the growth becomes inextricably linked to the marital effort. This is why forensic accounting has become a multi-billion-dollar industry in the United States. Professionals must go back through 16 years of quarterly statements to prove which dollars were the seeds and which were the fruit. If Michael cannot produce those statements from 2010, the court might default to the assumption that the entire account is marital property, potentially costing him hundreds of thousands of dollars in future retirement security. Now, consider the high-stakes world of the 401k loan. In the current economic climate of 2026, many families have used 401k loans to consolidate high-interest debt or to fund home renovations. Imagine Sarah and Michael took out a $50,000 loan from Michael's 401k in 2024 to redo their kitchen. In a divorce, this loan is a ticking time bomb. Because a 401k loan is essentially you borrowing from yourself, it is not considered debt in the traditional sense by many banks, but it is a massive liability in family court. If Michael is the one who remains at the company, he is responsible for paying back that loan through payroll deductions. However, if the court awards Sarah 50% of the total account value, does that 50% include the outstanding loan balance? If the account has $400,000 in cash and a $50,000 loan, is Sarah's half $200,000 or $225,000? If the court rules that the loan was a marital debt used for a marital purpose, Michael might find himself in a position where he has to pay Sarah her half while also being the only one paying back the loan to the account. This effectively means Michael is paying Sarah twice for the same kitchen renovation. This scenario plays out in thousands of courtrooms across the country, leading to what is known as the double-dip trap. Beyond the loans, we have to look at the psychological and tactical use of the 401k as a bargaining chip, often referred to as the offset method. In 2026, with interest rates and housing prices remaining a significant barrier for many Americans, the marital home is often the only asset that rivals the 401k in value. Imagine a scenario where Sarah wants to keep the house to provide stability for their 2 children. The house has $300,000 in equity. Michael's 401k also has $300,000 in marital value. On paper, it looks like a perfect one-for-one swap. Sarah keeps the house, Michael keeps the 401k, and they both walk away with $300,000 in net worth. This is a common historical trend in U.S. settlements, but it is fundamentally flawed from a financial perspective. This is because you are comparing apples to oranges. The $300,000 in the house is largely post-tax equity. If Sarah sells the house, she may have a significant capital gains exemption under Section 121 of the Internal Revenue Code. However, the $300,000 in Michael's 401k is pre-tax money. When Michael eventually retires and withdraws that money, he will be taxed at ordinary income rates. If his effective tax rate in retirement is 25%, his $300,401,000 is actually only worth $225,000 in real-world spending power. By agreeing to a straight swap, Michael has effectively handed Sarah $75,000 more in actual value. In 21st century divorce negotiations, savvy litigants now insist on a tax-affected valuation. They apply a hypothetical tax rate to the retirement account before comparing it to the home equity. Without this step, the person walking away with the retirement account is starting their new life at a massive disadvantage. Step by step, the process of valuation in 2026 requires a high degree of precision. First, you must obtain the summary plan description. This document is the Bible of the 401k plan. It dictates whether the plan even allows for a QDRO, what the fees are for processing it, and how it handles market fluctuations between the date of the divorce and the date of the actual transfer. Many people do not realize that it can take 6 to 12 months for a QDRO to be drafted, approved by a judge, and implemented by the plan administrator. If the stock market drops 20% in that 6-month window, who bears the loss? If the court order says Sarah gets exactly $100,000, Michael bears the entire market loss. If the order says Sarah gets 50% of the account, they share the loss. This single detail in the phrasing of a legal document can change the outcome by tens of thousands of dollars. As we look at the historical data from the mid-2020s, we see a rise in the use of multiple 401k accounts. The average American worker now changes jobs every 4 years. This means that by the time of a divorce, there might be 4 or 5 different 401k accounts from previous employers scattered across different financial institutions. Each one of these requires its own separate QDRO. Each one carries its own set of fees. If each QDRO costs $2,000 to draft and $500 for the plan administrator to review, A couple with 5 accounts is looking at $12,500 in administrative costs alone just to split their retirement. This administrative burden often leads to the consolidation of accounts during the divorce process, which brings us back to the danger of commingling. But there is a darker side to the 21st century 401k divorce. It involves the intentional depletion of assets. In a high-conflict divorce, one spouse might attempt to take out maximum loans, or even liquidate a portion of the account before the other spouse can file a joinder. A joinder is a legal action that joins the retirement plan itself as a party to the divorce, effectively freezing the account. In the age of instant mobile banking, a spouse can initiate a loan or a hardship withdrawal in seconds, while the court can later order them to reimburse the estate. If the money has already been spent or moved into untraceable assets, the other spouse is left chasing a ghost. We are moving into an era where the 401k is not just a savings vehicle. It is a complex legal entity that requires its own defense strategy. As we continue this deep dive, we must look at what happens when the 401k is not just holding stocks and bonds, but is a self-directed account holding real estate or private equity. The valuation challenges there make a standard stock portfolio look like child's play. And we haven't even touched on the most controversial aspect of all. What happens when one spouse has a secret 401k that was never disclosed during the marriage? How does the law track down hidden digital wealth in 2026? These are the questions that define the next decade of American family law. But before we get to the hidden assets, we have to talk about the absolute worst mistake you can make during the QDRO process. A mistake so common that it has its own name in the legal world, and it can result in a total loss of benefits for the non-employee spouse. We will explore the chilling reality of the surviving spouse trap, and how a single missed checkbox can erase 20 years of expected income. The surviving spouse trap is perhaps the most devastating technicality in the history of 21st century retirement law. To understand why, we have to look at the transition period between the signing of a divorce decree and the formal approval of a qualified domestic relations order. In the year 2026, the legal system moves faster in some ways, but the administrative gears of multi-billion-dollar retirement funds move with glacial caution. Imagine a woman named Jennifer who has just finalized her divorce from her husband, David, after 22 years of marriage. The judge signs the judgment of dissolution in June. According to that judgment, Jennifer is awarded 50% of David's 401k, which is valued at $800,000. Jennifer breathes a sigh of relief, believing the battle is over. However, the QDRO, the actual bridge that moves the money, has not been drafted yet. While Jennifer's attorney is busy exchanging drafts with David's attorney, a process that can easily take 3 to 4 months, something unexpected happens. David passes away in July. Under the standard terms of most 401k plans governed by the Employee Retirement Income Security Act, or ERISA, the beneficiary of the plan is the person listed on the plan's designation form. Because the divorce was just finalized, David had not yet updated his beneficiary. Even if the divorce decree says the 401k is split, the plan administrator is legally bound to pay the designated beneficiary. If David had updated his beneficiary to his sibling or a new partner immediately after the divorce papers were filed, Jennifer might find herself in a legal vacuum where the plan pays the full amount to the named beneficiary, leaving her with a signed piece of paper from a family court judge that the federal retirement plan refuses to honor. Historical trends in U.S. case law, specifically the landmark Supreme Court case Kennedy v. Plan Administrator for DuPont Savings and Investment Plan, established that the plan documents trump the divorce decree. This created a standard where the plan administrator is not a mind reader. They follow the internal forms of the company. In 2026, this means that if your QDRO does not include a specific provision naming you as the surviving spouse for the purposes of the plan until the money is actually transferred, you are standing on a trapdoor. Professionals now use what is known as a restraining order on assets or a joinder to prevent any changes to beneficiary designations during the litigation. But many self-represented litigants or those with general practice attorneys miss this step entirely. Step by step, the protection of these funds requires an immediate notification to the plan administrator the moment a divorce is even contemplated, followed by a preliminary QDRO filed simultaneously with the divorce judgment. Beyond the survival trap, we must analyze the specific mechanics of the valuation date, which is another area where thousands of dollars are lost in the margins. In the volatile market of 2026, the value of a 401k can swing by 5 to 10% in a single week. Let's look at a case study involving a tech worker in Austin named Marcus. Marcus and his spouse agreed to a divorce date of January 1st. On that day, the 401k is worth $1 million. However, the QDRO isn't processed until September 1st. By September, the market has performed well, and the account is now worth $1.2 million. Does the spouse get 50% of the January value, $500,000, or 50% of the September value, $600,000? If the legal language in the QDRO specifies a fixed dollar amount as of a specific date, the spouse gets $500,000 and loses out on $100,000 of growth. Conversely, if the market had crashed and the account dropped to $800,000, Marcus would still owe the $500,000, leaving him with only $300,000. This is why 21st century legal experts insist on language that includes earnings and losses. By specifying that the alternate payee receives a percentage of the account as of a specific date, adjusted for investment earnings and losses until the date of distribution, both parties share the market risk and the market reward. Failing to include the phrase earnings and losses is one of the most common oversights in modern domestic relations orders, and it leads to endless litigation after the divorce is supposedly final. We also have to address the massive shift in how the U.S. workforce handles employer matching and vesting schedules. In 2026, many 401k plans use tiered vesting to retain talent. Imagine Sarah, who started a high-paying role at a pharmaceutical giant 2 years before her divorce. Her company matches 6% of her salary, but those matching funds do not vest until she has been with the company for 5 years. At the time of the divorce, her account shows a balance of $200,000, but only $150,000 is vested. Is the non-employee spouse entitled to a portion of the unvested funds? The historical consensus in many U.S. states is that unvested retirement benefits earned during the marriage are marital property because they represent a contingent personal property interest. However, you cannot transfer unvested money. This creates a situation where the QDRO must be written to stay open for years. The plan administrator is essentially told to wait until the vesting period is met, then calculate the marital portion and move it. This requires the ex-spouses to remain financially tethered for years after their personal relationship has ended. For many, this is an emotional burden that leads to the trade-off strategy we discussed earlier, where one person takes a different asset just to achieve a clean break. Data from the Bureau of Labor Statistics and independent financial surveys show that the 401k is now the second most litigated asset in American divorces, surpassed only by the marital home. But unlike the home, the 401k is invisible. It doesn't have a yard sign or a roof that needs fixing. It is a digital number that represents a lifetime of labor. This invisibility often leads to the problem of the phantom loan. In 2026, with the rise of digital-first 401k platforms, many employees can take out a primary residence loan or a hardship withdrawal with a few taps on a smartphone. Historically, these required more paperwork and often a spouse's signature. However, many modern plans allow for small loans or specific withdrawals without spousal consent if the plan is not a defined benefit plan. A spouse who is planning to file for divorce might quietly drain the account of $50,000 to pay for their own legal retainers or to hide cash in other vehicles. By the time the other spouse discovers the withdrawal during the discovery phase of the divorce, the money is gone. This leads us to the critical role of the plan administrator. In 21st century U.S. history, the administrator is the gatekeeper. They do not care about your divorce decree. They do not care what the judge said about who was at fault for the breakdown of the marriage. They only care about the written terms of the plan and the federal law. If you call a plan administrator to ask about your spouse's account, they will not talk to you without a subpoena or a signed authorization. This creates a wall of silence that can be terrifying for a non-earning spouse who has no idea if their retirement is being protected. The strategy for 2026 involves the immediate issuance of a subpoena duces tecum to the plan administrator the moment the divorce petition is served. This requires the administrator to produce the full history of the account, including all loan applications, beneficiary changes, and contribution histories. This transparency is the only way to prevent the manipulation of the numbers. But even with transparency, there is a final hurdle that many don't see coming: the QDRO processing fee. In the past, companies handled this as part of their HR benefits. Today, most have outsourced this to third-party firms that charge anywhere from $500 to $1,500 per order, often deducted directly from the 401k account itself. If this fee isn't allocated in the divorce agreement, it can trigger a new dispute over who is responsible for the final cost of the split. As we move deeper into this masterclass, we are going to look at the intersection of 401ks and other modern assets. What happens when your 401k offers a brokerage link that allows you to invest in high-risk assets or even cryptocurrency? How do you value a 401k that is holding volatile digital assets on the day of the split? And more importantly, what happens when the 401k isn't the only bucket? We have to discuss the Roth 401k versus the traditional 401k, because giving up 50% of a Roth is giving up significantly more value than 50% of a traditional. But there is one specific type of retirement vehicle that is even more difficult to divide than a 401k. A vehicle used by executives and business owners that often remains completely hidden until it is too late to claim. We are going to unmask the world of non-qualified deferred compensation and why it is the ultimate weapon in high net worth divorce. The world of non-qualified deferred compensation, often referred to as NQDC or top hat plans, represents the invisible tier of executive wealth in 21st century U.S. history. Unlike the 401k, which is governed by the strict, transparent rules of ERISA, these plans are essentially unsecured promises from an employer to an employee. Imagine a high-level executive named Robert working for a multinational tech firm in 2026. Robert has a standard 401k with a balance of $600,000. During his divorce from his spouse, Elena, the 401k is disclosed immediately. However, Robert also participates in an NQDC plan where he has deferred 20% of his million-dollar bonuses over the last 5 years. This side account holds over $1 million, yet it does not appear on his standard 401k statement. Historically, these plans are used to allow high earners to bypass the contribution limits imposed on 401ks. In 2026, those limits are strictly enforced by the IRS, making deferred compensation the primary way the wealthy build tax-deferred retirement engines. The danger for a spouse like Elena is that these plans are often not funded in the traditional sense. They are merely entries on a company's balance sheet. Because they are not governed by ERISA, they do not follow the standard QDRO process. You cannot simply send a QDRO to the plan administrator and expect a separate account to be created for the ex-spouse. In many cases, the plan documents explicitly forbid the assignment of benefits to anyone other than the employee. This means that even if a judge orders the account to be split, the company might refuse to honor the order. Case studies in high net worth divorces show that the only way to reach these assets is through a constructive trust or a distributive award. This means the court orders Robert to pay Elena her share of the deferred compensation out of other marital assets, or orders him to pay her as he receives the payments years down the line. Imagine the risk Elena takes if she agrees to wait 10 years for Robert to retire to get her share of that deferred money. If the company goes bankrupt in 2029, those deferred compensation plans are treated as general unsecured debt. Robert loses his money, and Elena loses her claim. In 21st century litigation, the strategy shifted towards seeking an immediate buyout of these interests. Step by step, this requires a valuation expert to calculate the present value of that future promise, accounting for the risk of company insolvency and the inevitable tax hit Robert will take when the money is finally paid out. While we are discussing the nuances of 2026 wealth, we must address the fundamental difference between the traditional 401k and the Roth 401k in a divorce settlement. Historical trends show that many couples treat these as identical assets because the total balance on the screen looks the same. Imagine a couple, James and Linda. James has a traditional 401k with $400,000. Linda has a Roth 401k with $400,000. They decide to each keep their own account, thinking it is an even split. This is a catastrophic mistake. In a traditional 401k, every dollar James withdraws in retirement will be taxed as ordinary income. If he is in a 25% tax bracket, his $400,000 is actually worth $300,000 in purchasing power. Linda's Roth 401k, however, was funded with post-tax dollars. Every cent of her $400,000, including the decades of growth, will be hers to keep tax-free. In the eyes of a 2026 financial planner, Linda is effectively 33% wealthier than James, despite their account balances being identical on the day of the divorce. This disparity has led to a rise in tax-affecting negotiations where the traditional 401k is discounted by a projected future tax rate to reach a true equitable distribution. If you are not looking at the tax status of each specific subbucket within the retirement plan, you are not actually doing the math of the divorce. Another 21st century complication is the rise of the self-directed 401k or the brokerage link option. In previous decades, 401k plans offered a limited menu of 10 to 20 mutual funds. By 2026, Many plans allow employees to open a window to the entire stock market, including individual stocks, options, and even certain alternative assets. Imagine if James had used his 401k to buy a significant amount of a volatile tech stock, or a specialized exchange-traded fund that tracks a niche industry. On the day of the divorce filing, the stock is trading at record highs. By the time the QDRO is processed 6 months later, the industry has shifted, and the value has plummeted. This brings us to the concept of the valuation date versus the distribution date. Historical data from U.S. family courts indicates that the choice of valuation date can be the most contentious part of the entire trial. Some states use the date of separation, while others use the date of the trial. In a volatile market, a 6-month delay in the court system can result in one spouse receiving a windfall while the other is left with a hollowed-out account. To mitigate this, 2026 legal teams often use a pro rata share of the actual holdings. Instead of Sarah getting $100,000, she gets a specific number of shares in each fund James holds. This ensures that whatever happens to the market between the courtroom and the bank, both parties feel the same impact. We must also look at the impact of 401k fees on the final settlement. Modern 401k plans often have layers of fees: administrative fees, investment management fees, and the aforementioned QDRO processing fees. In a divorce involving a large sum, say $2 million, these fees can be substantial over the time it takes to finalize a split. If the plan administrator charges a 1% annual fee for a managed account, and the divorce takes 2 years to resolve, that is $40,000 drained from the marital pot. Who pays for that? If James is the one managing the account and he chooses a high-fee fund during the divorce proceedings, Linda's attorney might argue that he has committed a breach of fiduciary duty to the marital estate. This leads us to the terrifying concept of waste or dissipation of assets. In 21st century U.S. history, the court looks closely at any unusual activity in a 401k leading up to a divorce. Imagine if 6 months before filing, James took a maximum loan from his 401k and used the cash to fund a lifestyle his spouse was unaware of, or worse, to invest in an asset held in someone else's name. This is known as financial misconduct. In 2026, forensic technology allows investigators to track the digital footprint of every transaction. If the court finds James intentionally depleted the 401k to reduce the amount Linda would receive, the judge can award Linda a greater share of the remaining assets to make her whole. This is called a recapture or an unequal distribution. Step by step, protecting a 401k in 2026 requires more than just a lawyer. It requires a coordinated team. You need a family law attorney to handle the state-level statutes, a QDRO drafter who understands federal ERISA law, and often a certified divorce financial analyst to project the long-term tax consequences. The historical trend is moving away from simple splits and toward complex financial modeling. This is because the 401k is no longer just a retirement account. For the American middle class, it is the primary engine of multi-generational wealth. But what happens when the 401k is combined with an IRA? Many people roll over their 401k funds into an individual retirement account when they change jobs. The rules for dividing an IRA are completely different from a 401k. There is no QDRO for an IRA. Instead, you use a process called a transfer incident to divorce. If you use the wrong paperwork or the wrong terminology, the IRS will view the transfer as a taxable distribution, and you will be hit with a massive tax bill that could have been entirely avoided. We are going to break down the specific traps of the IRA rollover, and why moving money between different types of retirement accounts during a divorce is the fastest way to trigger an audit in 2026. But first, we need to address the most misunderstood figure in the room: the plan administrator's representative, and why their advice might actually be a trap designed to protect the company, not you. The plan administrator is a fiduciary to the plan, not to you or your spouse. In 2026, many major U.S. corporations have automated their HR systems, meaning when you call to discuss the division of a 401k, you are often speaking to a third-party contractor who is reading from a script designed to minimize company liability. Imagine a teacher named Karen who is divorcing after 30 years. She calls her husband's plan administrator to ask how to secure her half of his $2 million account. The representative tells her, "Don't worry, just send us the final divorce decree, and we will take care of it." Karen follows this advice, waits for the final judgment, and sends it in. Only then does the administrator inform her that the decree is not a qualified domestic relations order and therefore cannot be honored. By the time Karen hires a specialist to draft a proper QDRO, Her ex-husband has already retired and started taking lump sum distributions, significantly reducing the pool of money available to her. This is a classic historical trend where the lack of specific technical knowledge results in a loss of leverage. Step by step, you must understand that the plan administrator's primary goal is to ensure the plan remains qualified under IRS rules. If they move money without a document that meets every single requirement of Section 414 of the Internal Revenue Code, the entire 401k plan for every employee in the company could lose its tax-exempt status. Because the stakes are so high for the company, they will reject your QDRO for the smallest clerical error. This is why in 2026, the gold standard is to submit a draft QDRO for pre-approval before the judge ever signs it. If you skip pre-approval, you are essentially gambling with your timeline. A rejection from an administrator after a judge has signed the order means you have to go back to court, file a motion to amend, and potentially pay thousands more in legal fees. Now let's pivot to the individual retirement account or IRA, and why it is a completely different animal in 21st century US history. Imagine a scenario involving a small business owner named Thomas. Thomas has an IRA worth $900,000. Unlike a 401k, an IRA is not governed by ERISA. There is no such thing as a QDRO for an IRA. Instead, the law uses Section 71 of the tax code to facilitate a transfer incident to divorce. While this sounds simpler, the margin for error is actually thinner. In a 401k split, the plan administrator acts as a secondary check. In an IRA split, the burden is almost entirely on the individuals and their financial institutions. If Thomas decides to simply write a check to his ex-spouse from his IRA, the IRS will treat that as a taxable distribution to Thomas. He will owe immediate income tax and, if he is under 59.5, a 10% penalty. To do this correctly in 2026, the transfer must be a direct trustee-to-trustee transfer. The money moves from Thomas's IRA directly into an IRA established for his ex-spouse. Case studies from recent years show that even a small mistake, like moving the money into a standard brokerage account instead of a designated IRA, can trigger an irreversible tax event. The historical data indicates that the IRS is increasingly vigilant about these transfers, as they represent a significant portion of tax-deferred wealth. Furthermore, we must discuss the 2026 landscape of the indirect rollover trap. Some people attempt to take a 60-day distribution from their retirement account during a divorce to use as a temporary loan for a new house or legal fees, intending to put it into a new account within the 60-day window. This is high-risk behavior in a divorce. If the divorce proceedings hit a snag and the money isn't rolled over in time, the person who took the distribution is hit with a massive tax bill. In the context of a 401k versus an IRA, the 401k offers more protection through the QDRO, because the law allows for a penalty-free distribution to an alternate payee. An IRA does not offer this specific 10% penalty waiver for early distributions to an ex-spouse, unless they are over 59.5. This makes the 401k a more flexible tool for couples who need liquidity during their transition. Let's look at a case study of a mid-level manager in Chicago named David. David has both a 401k from his current job and an IRA from a previous job rollover. During his divorce in 2026, he needs to give his spouse, Lisa, $400,000. If he takes that money from his IRA, he might trigger penalties. If he takes it from his 401k via QDRO, Lisa can take the cash distribution without the 10% penalty, though she still pays the income tax. This nuance is why a 2026 financial strategy must look at the specific tax code sections for each type of account. Historical trends show that many divorce lawyers who do not specialize in financial matters treat all retirement accounts as a single category, which is a disservice to the client's long-term net worth. Deepening our dive, we have to address the issue of cost basis and embedded tax liabilities. This is where 21st century accounting meets matrimonial law. Imagine if Thomas's IRA isn't just cash. Imagine it holds shares of a company he bought years ago that have grown 500% in value. If Thomas keeps the high-growth shares and gives his spouse the cash-equivalent shares that have not grown, he is keeping an asset with a massive future tax bill. In 2026, sophisticated litigants are using shadow tax returns to project what the actual value of an account will be after the IRS takes its share. They are no longer looking at the current balance. They are looking at the net after-tax proceeds. Another critical factor in 2026 is the role of the 401k beneficiary designation versus the last will and testament. In the United States, your 401k is a non-probate asset. This means it passes outside of your will. We have seen historical cases where an individual gets divorced, forgets to change their 401k beneficiary, and then passes away 10 years later. Even if their will says everything goes to their new spouse or their children, the 401k administrator is legally required to pay the ex-spouse listed on the form. In 21st century U.S. history, this is known as the ghost of the ex-spouse. To prevent this, many states have passed revocation on divorce statutes, which automatically remove an ex-spouse as a beneficiary upon a final divorce decree. However, because 401ks are governed by federal ERISA law, these state statutes are often preempted. Federal law usually wins, meaning the name on the form is the only name that matters. As we move forward, we have to look at the emerging complexity of the 401k in an era of gig work and self-employment. The solo 401k has become a popular vehicle for freelancers and consultants in 2026. Dividing a solo 401k in a divorce is a legal minefield because the employee and the plan administrator are often the same person. This creates an inherent conflict of interest. If Thomas is the administrator of his own solo 401k, he might be tempted to delay the QDRO process or provide incomplete data to his spouse's legal team. The 21st century approach to this involves the appointment of an independent fiduciary to oversee the division of self-managed plans. We are seeing a rise in court-appointed masters who specialize in these niche retirement vehicles. But even with an expert, the question of valuation remains. How do you value a 401k that holds an interest in a private business or a piece of commercial real estate? These alternative investments, which are becoming more common in high-end 401k plans, require appraisals that can cost $5,000 to $10,000 each. In the next part of this masterclass, we are going to tackle the most controversial strategy of the modern era: the use of the 401k as a shield against alimony. We will explore how some individuals are over-contributing to their retirement accounts in the years leading up to a divorce to artificially lower their disposable income and reduce their spousal support obligations. This is the world of income manipulation, and the 2026 legal system is finally catching up. But before we get there, we must look at the one document that can override every law we've discussed so far, the prenuptial agreement, and why most of them are currently being thrown out of court because of how they handled the 401k. The prenuptial agreement is often touted as the ultimate shield for personal wealth, but in the specific context of the 401k, it is frequently the weakest link in a legal defense. To understand why so many of these documents are failing in 2026, we have to look at the collision between contract law and federal ERISA statutes. Imagine a professional named Christopher who married his spouse, Allison, in 2018. Before the wedding, Christopher insisted on a prenuptial agreement stating that his 401k, then worth $200,000, and all future contributions and growth would remain his separate property in the event of a divorce. They both signed it and it was notarized. Fast forward to 2026, and the couple is in divorce court. Christopher's 401k is now worth $800,000. He presents the prenup as a total defense, only to have the judge rule that the waiver of the 401k is invalid. This happens because of a very specific federal requirement. Under ERISA and the Internal Revenue Code, a spouse can only waive their right to a retirement plan survivor benefit if they are currently a spouse. Because Christopher and Allison were not yet married when they signed the prenuptial agreement, Allison was not a spouse, she was a fiancée. Therefore, her signature on that document was legally incapable of waiving her future rights to the 401k under federal law. Historical trends in U.S. case law show that unless the prenuptial agreement includes a specific clause requiring the spouse to sign a secondary waiver after the wedding ceremony is performed, the initial waiver is often treated as a nullity. Thousands of individuals in the 21st century have discovered this reality too late, watching their protected asset be divided because they missed the post-wedding administrative step. Step by step, a robust strategy in 2026 requires the couple to execute a postnuptial confirmation or a specific spousal waiver form provided by the 401k plan administrator within 30 to 90 days after the marriage. Without this, the 401k remains a marital asset in the eyes of federal law, regardless of what the premarital contract says. This is a nuance that even many high-priced family law attorneys overlook, and it is a prime example of why the 401k is the most dangerous asset in the American legal system. Moving deeper into the mechanics of 2026 financial maneuvers, we must address the use of the 401k as a tool for income manipulation, specifically regarding alimony or spousal support. Imagine a case study involving an executive named Michael, who earns $400,000 a year. In the 2 years leading up to his divorce, Michael drastically increases his 401k contributions, maximizing his catch-up contributions and utilizing every available tax-deferred vehicle provided by his company. His goal is to lower his adjusted gross income, so that when the court calculates his ability to pay alimony, he appears to have less disposable cash. Historical trends show that 21st century courts have become increasingly wise to this tactic. In many U.S. jurisdictions, judges now distinguish between mandatory deductions and voluntary deductions. While taxes and union dues are considered mandatory, contributions to a 401k are almost always seen as voluntary. In 2026, a judge will likely add those contributions back into Michael's income for the purposes of calculating support. This is known as imputing income. However, the data becomes murky when the contributions were a long-standing habit. If Michael had been contributing the same percentage for 15 years, the court might view it as a legitimate living expense. If he doubled his contribution the month he moved out of the marital home, it is flagged as a bad faith move. This leads us to the concept of the 401k as a shield against creditors and judgment creditors, which takes on a different light in a divorce. While a 401k is generally protected from most creditors under ERISA, a spouse is not a standard creditor. A spouse is a co-owner. This is why the 401k cannot be used to hide money from the domestic relations court. But what about the 401k as a source of payment for alimony? In 2026, we are seeing a rise in what is called an alimony QDRO. Instead of Michael writing a check to Allison every month for $5,000, the court issues a QDRO that pays Allison directly from Michael's 401k account. This provides Allison with security because the money is guaranteed by the plan administrator, and it provides Michael with a tax-efficient way to settle his obligation, as the tax liability moves with the money to Allison. Let's look at the specific data regarding the 401k and the gender wealth gap in 21st century U.S. history. Historical data from the mid-2020s suggests that women still have significantly lower 401k balances on average than men, often due to time taken out of the workforce for caregiving. In a divorce, the 401k division is often the only mechanism to correct this imbalance. Imagine a woman named Maria who stayed at home for 10 years to raise children while her husband, David, built a massive 401k at a software company. Without the 401k division, Maria would enter her 50s with zero retirement savings. The 401k split is not just a financial transaction. It is a structural necessity for the social safety net of American women. This is why the rules around QDROs are so strictly guarded by federal policy. However, the 401k division can also be used as a weapon in a high-conflict divorce. Imagine if David, knowing he has to split the account, decides to move the entire balance into high-risk, speculative investments. In 2026, many 401ks offer brokerage links that allow participants to trade individual stocks or leveraged ETFs. If David loses 50% of the account value in a bad trade during the divorce, does Maria still get half of the original value? This falls under the legal theory of dissipation of marital assets. If Maria can prove that David's investment choices were a reckless departure from his historical investment pattern, the court can hold him responsible for the loss. They can credit Maria with the value the account would have had if it had been left in a standard target date fund. Step by step, the discovery process in 2026 involves more than just looking at the current balance. It requires a deep dive into the transaction history. Attorneys are now looking for unusual investment shifts, undisclosed loans, and even the timing of dividend distributions. If a dividend was issued and then immediately moved to a side account, that is a red flag for hidden assets. The 401k statement is no longer a static document. It is a forensic roadmap. Another critical trend we are seeing in 2026 is the impact of the 401k on the Social Security offset. In some states, if one spouse has a public pension and the other has a 401k, the court must perform a complex calculation to equalize the two. Because the person with the pension might not be eligible for full Social Security benefits due to the windfall elimination provision, the 401k becomes the balancing factor. This is a level of math that requires a specialized actuary. If you treat $1,000 of monthly pension as equal to $1,000 of 401k balance, you are making a massive error in favor of the pension holder. We must also consider the role of the 401k in the current interest rate environment. In 2026, with rates fluctuating, the present value of future retirement benefits is a moving target. If a couple is negotiating an offset where one takes the 401k and the other takes a cash buyout, the discount rate used to calculate that present value can change the outcome by 6 figures. If the discount rate is too high, the person getting the 401k is being overcharged. If it is too low, they are getting a steal. As we continue this masterclass, we are going to look at the global aspect of the 401k. What happens when an American worker has a 401k but is divorcing a spouse who lives in a country that does not recognize QDROs? How do you enforce a U.S. court order against a domestic retirement plan when the recipient is overseas? This is the new frontier of international matrimonial law. But before we cross borders, we have to talk about the most common mistake made during the actual transfer of funds. A mistake that happens at the very end of the process and can lead to the IRS freezing both parties' accounts. We are going to examine the nightmare of the botched rollover and the 401k check that never arrived. The nightmare of the botched rollover often begins with a simple clerical error or a misunderstanding of how the United States banking system interacts with federal tax law in 2026.
Imagine a scenario involving a healthcare administrator named Elena.
After 18 months of litigation, her QDRO is finally approved. The plan administrator issues a check for $400,000, representing her half of the marital 401k. However, instead of making the check payable to the financial institution for the benefit of Elena's IRA, the administrator makes the check out directly to Elena. In the eyes of the IRS, the moment that check is issued in her name, it is a taxable distribution. Historical trends show that once a check is issued incorrectly, correcting the tax reporting is an uphill battle. If Elena deposits that check into her personal savings account, she has triggered a massive income tax event. Even if she realizes the mistake and moves it to an IRA within 60 days, she may still face issues with mandatory 20% federal withholding that was taken out before the check ever reached her. This means she only received $320,000, but she needs to deposit the full $400,000 to avoid taxes and penalties on the $80,000 difference. Finding $80,000 in cash during a divorce is a hurdle most Americans cannot clear. This is why in 21st century U.S. history, the direct trustee-to-trustee transfer is the only recommended path. Step by step, you must ensure that the QDRO specifically mandates a direct rollover and provides the exact name of the receiving institution. Let us expand on the data regarding the 401k check that never arrives. In 2026, many 401k plans have transitioned to digital-only disbursements, but many still rely on physical mail for large QDRO settlements. Case studies from recent years highlight a growing problem of mail theft and fraudulent interception of retirement checks. Imagine if that $400,000 check for Elena is stolen from a mailbox. While the funds are technically still in the plan, the administrative process to void and reissue a check of that magnitude can take months, during which the market may fluctuate wildly. If the market rises 10% while Elena is waiting for her replacement check, she has lost $40,000 in potential growth. In 2026, sophisticated legal teams insist on electronic fund transfers or wire transfers for QDRO payouts to eliminate the physical risks of the U.S. Postal Service. Moving into the granular details of 21st century valuation, we must discuss the issue of the 401k plan's administrative expenses. Many people do not realize that the costs of maintaining a 401k are often passed down to the participants. In a divorce, these costs can become a point of contention. Imagine a scenario where the 401k plan has a high expense ratio because it includes expensive actively managed funds. Over the course of a 2-year divorce, these fees could eat away 2 or 3% of the total account value. If one spouse is the plan participant and the other is the alternate payee, who bears the burden of these fees? Historical trends in court rulings suggest that unless specified otherwise, the fees are shared proportionally. However, if the participant spouse intentionally chose high-fee funds to spite the other spouse, this could be argued as a breach of fiduciary duty to the marital estate. The concept of the 401k as an umbrella for multiple subaccounts is another area where deep dives are necessary. In 2026, it is common for a single 401k to contain a traditional pre-tax bucket, a Roth post-tax bucket, and perhaps a company stock match bucket. If a QDRO simply says give 50% to the ex-spouse, which bucket does the money come from? If the administrator takes 50% from each, that is one outcome. But if they take it all from the traditional bucket because it is easier to calculate, the recipient spouse is left with a much higher future tax bill than if they had received a portion of the Roth bucket. Step by step, the 2026 QDRO must specify the allocation between these subaccounts. Failure to do so is a common cause of post-divorce litigation, as parties realize months later that the tax value of their shares is not equal. Now, consider the high-stakes environment of the 401k loan repayment during a divorce. We touched on this briefly before, but the 2026 reality is even more complex. If an employee spouse has an outstanding loan, and then leaves the company during the divorce, the loan often becomes due immediately. If it is not paid back, it is treated as a deemed distribution, meaning it is taxed as income. This can create a sudden tax liability of tens of thousands of dollars, right when the couple is trying to divide their assets. Imagine a character named Mark who loses his job in the middle of a divorce, while he has a $40,000 401k loan. That $40,000 is suddenly added to his taxable income for the year 2026. If the divorce settlement was based on the assumption that the 401k was worth more than it actually is after this tax event, the entire financial structure of the divorce collapses. Historical data shows that the 401k is often the only liquid or semi-liquid asset available to pay for the divorce itself. In 2026, we see more people using the QDRO as a way to access cash. Under Section 72(2)(c) of the Internal Revenue Code, an alternate payee who receives a distribution from a 401k via a QDRO can take that money as cash without paying the 10% early withdrawal penalty, regardless of their age. This is a unique feature of the 401k that is not available for IRAs. For many Americans, this is the only way to fund a retainer for a lawyer or pay for a security deposit on a new apartment. However, the catch is the mandatory 20% federal withholding. If you need $50,000, you have to ask for $62,500. This depletion of the retirement corpus is a historical trend that is significantly impacting the retirement readiness of the Gen X and Millennial cohorts as they navigate 21st century divorces. We must also look at the role of the 401k in the context of the 2026 housing market. Because many people cannot afford to buy out their spouse's interest in the marital home with cash, they use a 401k offset. But how do you calculate the fair exchange rate? $1 in a house is not $1 in a 401k. To get to a fair number, you must account for the real estate commission that would be paid if the house were sold, the capital gains tax if the gain is over the $500,000 exclusion, and the future income tax on the 401k. In 2026, this is done using a net equity analysis. If you are not using a spreadsheet that accounts for at least 6 different variables, you are not getting an accurate picture of your wealth. Step by step, a 401k division involves a timeline that most people are unprepared for. Phase 1 is discovery, where you gather statements. Phase 2 is valuation, where you determine the marital versus separate portions. Phase 3 is the negotiation of the QDRO terms. Phase 4 is the court approval. Phase 5 is the plan administrator's review. Phase 6 is the actual transfer. In 2026, this timeline can stretch over 2 years. During those 2 years, the 401k participant has total control over the investment choices. This leads to the potential outcome of investment paralysis or investment aggression. If the participant's spouse stops managing the account out of fear or spite, and the market turns, the loss is shared by both. As we look toward the future of retirement and divorce in U.S. history, we are seeing the emergence of the 401k as a primary source for paying child support arrears. In 2026, some states have made it easier for the government to seize 401k assets to pay for unpaid support obligations. This means that before a 401k can be divided between spouses, there may be a lien on the account from the state. This adds yet another layer of complexity to the QDRO process. But what happens if the 401k isn't just a 401k? What if it's a 403b, a 457, or a thrift savings plan for federal employees? Each of these has its own specific rulebook and its own version of the QDRO. We are going to explore the unique dangers of the thrift savings plan and why federal employees face a different set of hurdles than private sector workers. But first, we have to talk about the nuclear option in a 401k divorce, the total liquidation of the account by one spouse before the other even knows the divorce is happening. We will look at how the law tries to claw back those funds and why it usually fails. The nuclear option of total 401k liquidation is a nightmare scenario that has haunted the halls of U.S. family courts for decades. But in 2026, the speed of digital banking has made it an instantaneous catastrophe. Imagine a husband named Gregory who realizes his marriage is ending. Before the summons and complaint are ever served, he logs into his workplace retirement portal. Under the guise of a financial emergency or a plan allowed withdrawal, he liquidates a $400,000 balance. He pays the taxes, accepts the 10% penalty as the cost of war, and moves the remaining cash into an offshore account or a high-limit physical asset like gold or high-end collectibles. By the time his spouse, Diane, files for divorce and her attorney sends a subpoena to the plan administrator, the account balance is zero. In 21st century U.S. history, this is known as the dissipation of marital assets, and the legal system's attempt to claw back these funds is often a lesson in frustration. Step by step, the court's primary tool is the credit or offset. If the judge finds that Gregory intentionally depleted the 401k to deprive Diane of her share, the court will award Diane a larger portion of the remaining assets, such as the marital home or other brokerage accounts. However, a significant problem arises in 2026 if the 401k was the only major asset. If there is nothing else to offset, Diane is left with a money judgment against Gregory. A money judgment is essentially a piece of paper stating he owes her $200,000, but enforcing that judgment against someone who has intentionally hidden their wealth is a process that can take years of additional litigation with no certainty of collection. Historical trends show that once retirement funds leave the protected shell of a 401k, they are rarely recovered in full. This brings us to the unique world of the Thrift Savings Plan, or TSP, which serves millions of federal employees and members of the uniformed services. While the TSP functions similarly to a 401k, it is not governed by ERISA. Instead, it is governed by the Federal Employees Retirement System Act. This means you do not use a QDRO. You must use a specialized document called a court order acceptable for processing, or COAP. This is a critical distinction in 2026. If an attorney drafts a standard 401k QDRO for a federal employee's TSP, the TSP board in Mississippi will reject it immediately. Case studies of federal employees, such as a postal worker named Henry or a military officer named Susan, highlight the rigid nature of the TSP. Unlike private sector plans that might allow for some flexibility in language, the TSP board requires exact phrases. For example, if you want the ex-spouse to receive a portion of the earnings and losses on their share from the date of divorce to the date of payment, the COAP must use the specific terminology recognized by the board. If it does not, the spouse only receives the static dollar amount as of the date specified, losing out on months or even years of market growth during the administrative delay. Historical data suggests that because the TSP is one of the largest retirement funds in the world, its administrators are among the most difficult to negotiate with, often taking 90 days just to provide an initial review of a draft order. Now let's explore the 401k's relationship with the 403b and 457 plans, which are commonly used by teachers, nurses, and government employees. In 2026, many households have a mix of these accounts. A 403b is very similar to a 401k and usually requires a QDRO. However, a 457 plan, specifically a non-governmental 457b plan, is a different beast entirely. These plans are often used by high-level executives at nonprofits or hospitals. Much like the non-qualified deferred compensation plans we discussed earlier, these assets are technically the property of the employer until they are paid out. In many cases, they cannot be divided by a QDRO at all. If a nurse practitioner named Sarah has a significant 457b balance, her spouse may be shocked to find that they cannot get a separate account in their own name. Instead, they must wait until Sarah retires or leaves the job to receive their share, or negotiate a buyout using other marital property. The data regarding these governmental and nonprofit plans shows a high rate of error in divorce settlements. Because the rules vary so wildly between a 401k and a 457, the potential outcomes for the non-employee spouse are highly dependent on the technical proficiency of their legal team. Imagine if Sarah's spouse agrees to take the 457b in the divorce, only to find out later that the plan does not allow for a lump sum transfer to an IRA. They are now stuck waiting decades for a payout that is subject to the nonprofit's continued solvency. This is the hidden risk of the 21st century retirement portfolio. Not all retirement dollars are created equal, even if the balances look the same on a screen. Step by step, the valuation of these plans also requires an understanding of the 401k's loan provisions. In 2026, we see an increasing number of participants taking out residential 401k loans to help pay for a new home after the split. If a loan is taken out after the date of separation but before the QDRO is finalized, it can create a massive accounting headache. If the account was worth $500,000 on the date of separation, but the participant takes a $50,000 loan a month later, the plan administrator may only see $450,000 of available cash. The QDRO must be written to account for the fact that the loan is the participant's sole responsibility and should be added back to the total value for the purpose of calculating the ex-spouse 50% share. Without this add-back clause, the ex-spouse effectively pays for half of the participant's new house. Historical trends also point toward a shift in how 401k match contributions are handled. Many companies in 2026 use a true-up contribution at the end of the year. If a couple divorces in June, but the employer doesn't put in the matching funds until January of the following year, who is entitled to the portion of the match that was earned during the marriage? A standard QDRO might miss this entirely. Sophisticated 2026 settlements include language that captures all future contributions or credits that are attributable to the marital period, even if those credits are not deposited until after the divorce is final. This is the level of detail required to protect every dollar of the marital estate. Furthermore, we must look at the psychological impact of the 401k division. In many U.S. households, the 401k is the primary symbol of security. Losing half of it can lead to a phenomenon known as investment trauma, where the remaining spouse becomes either overly aggressive in trying to win back the lost funds or overly conservative, moving everything to cash and losing out on the inflation-beating growth they need for retirement. Case studies from the mid-2020s show that individuals who go through a 401k split are 30% more likely to delay their retirement age compared to those who remain married. As we move toward the conclusion of this deep dive, we must address the most modern of all complications: the 401k that holds international assets or is part of a cross-border employment agreement. In 2026, with the rise of remote work, it is common for a US-based employee to have a 401k while working for a company headquartered in London or Tokyo. The interaction between US tax law and foreign pension treaties is a legal labyrinth. But even more pressing is the question of what happens when the 401k isn't just holding traditional stocks, but has integrated digital assets into its core options. How do you divide a 401k that is volatile enough to change in value by 20% during the time it takes the judge to sign the order? We are going to look at the volatility clauses that are saving people millions of dollars in 2026. But first, we have to talk about the final stage of the 401k journey, the actual retirement. What happens if you get a divorce after you have already started taking your required minimum distributions? We will explore why the IRS rules on RMDs can turn a simple split into a tax nightmare for the unprepared. The intersection of required minimum distributions, or RMDs, and the division of a 401k represents one of the most mathematically punishing chapters in 21st century U.S. history. For those who are divorcing later in life, often referred to as a silver divorce, the IRS clock does not stop just because a marriage is ending. In 2026, the age for starting RMDs has moved to 75 under the long-term rollout of the Secure Act 2.0, but many retirees are already in the middle of their distribution phase. Imagine a retiree named Arthur who is 76 years old. He has a $2 million 401k. By law, Arthur must withdraw a specific percentage of that account every year based on his life expectancy. If he fails to do so, the IRS imposes a massive excise tax on the amount that should have been distributed. Now, imagine Arthur is in the middle of a divorce from his spouse, Martha. The court is preparing a QDRO to give Martha $1 million. However, the year is half over, and Arthur has only taken a fraction of his required distribution. If the account is split mid-year, who is responsible for the RMD on the $1 million that moves to Martha? Historical trends in tax litigation show that the IRS generally views the person who holds the funds at the end of the year as the responsible party. But 401k plan administrators often have different internal protocols. If the QDRO is not explicitly clear about the RMD obligation, Arthur might take his full distribution early in the year to satisfy the law, only to find out that the plan administrator then takes a second distribution from the remaining balance to satisfy Martha's RMD once the account is split. This results in double taxation and a significant depletion of the principal. Step by step, the 2026 legal strategy for RMD age divorces involves a specific RMD accounting clause. This clause dictates that any distributions taken by the participant spouse during the calendar year of the split are credited against their share of the total asset. It also requires the alternate payee to acknowledge their responsibility for the RMD on the portion they receive after the transfer. Case studies from recent years indicate that without this level of detail, retirees often find themselves in an audit nightmare, trying to explain to the IRS why the 1099 are forms issued by the plan do not match the settlement agreement. Let us pivot to the concept of the volatility clause, a tool that has become indispensable in the high-frequency trading environment of 2026. Because 401k balances can fluctuate by tens of thousands of dollars while a judge is simply waiting for their morning coffee, the traditional method of assigning a fixed dollar amount is becoming obsolete. Imagine a character named Julian who is awarded $500,000 from his spouse's 401k. On the day the agreement is signed, $500,000 represents exactly 50% of the account. However, a market correction occurs 3 weeks later, and the total account value drops to $700,000. If the court order is for a fixed $500,000, Julian still gets his money, but his ex-spouse is left with only $200,000. This is an inequitable result that can lead to a motion to set aside the judgment. To combat this, the 21st century U.S. legal standard has shifted toward the use of percentage-based awards with a valuation date adjustment. Instead of a dollar figure, the order specifies that Julian receives 50% of the total account value as of the date of separation, adjusted for any subsequent investment earnings or losses. This ensures that Julian and his ex-spouse are in the same boat. If the market goes up, they both win. If it goes down, they both lose. Data from 2026 family law conferences suggest that percentage-based QDROs result in 70% less post-judgment litigation than fixed-dollar QDROs. This is the difference between a clean break and a decade of resentment. Furthermore, we must discuss the phenomenon of the 401k as a hidden source of insurance. In many modern employment packages, the 401k is tied to a group term life insurance policy. When the 401k is divided or when a QDRO is served, it can sometimes trigger a notification to the insurance carrier. In a divorce, the court often orders the participant spouse to maintain a life insurance policy to secure alimony or child support obligations. Historical trends show that if the 401k was the primary asset and it is depleted by a divorce, the participant might lose their eligibility for certain low-cost insurance riders associated with the plan. This creates a secondary financial hit that is often overlooked until it is too late to purchase a private policy. Let's look at a deep dive case study involving a self-employed consultant named Brenda. Brenda has a solo 401k, which allows for much higher contribution limits than a standard workplace plan. In 2026, Brenda has accumulated $1.5 million. During her divorce, her spouse, Kevin, demands half. However, because Brenda is both the employer and the employee, she has used the 401k to invest in non-traditional assets, including a small piece of commercial real estate held within a limited liability company owned by the 401k. Dividing a solo 401k that holds real estate is one of the most complex tasks in modern law. You cannot simply cut a building in half. The solution in 2026 often involves a specialized appraisal and a cross-collateralization agreement. Kevin might be awarded a lien against the property held within the 401k, or Brenda might have to take out a massive loan against her other assets to buy out Kevin's interest in the real estate portion of the retirement plan. This is where the historical trend of illiquid 401k investments meets the reality of divorce. As more Americans move toward self-employment and gig economy retirement structures, the traditional QDRO becomes less effective, and we see a rise in the use of independent trustees to manage the liquidation of these complex portfolios. The complexity deepens when we consider the impact of state-specific community property laws versus equitable distribution laws. In 2026, states like California and Washington continue to adhere to a strict community property standard where everything earned during the marriage is split 50-50, regardless of fault. However, in equitable distribution states like New York or Florida, the judge has the discretion to award a 60-40 or 70-30 split of the 401k if they find that one spouse contributed significantly more to the marriage or if one spouse has a much greater future need. Historical data indicates that the outcome of a 401k split can vary by hundreds of thousands of dollars, simply based on which side of a state line the couple resides. Step by step, the 2026 process for a high net worth 401k division also involves the analysis of the plan's summary plan description for a provision known as the separate interest versus shared interest payout. In a separate interest QDRO, the alternate payee's portion is carved out into a completely separate account. They can then choose their own investments and their own retirement date. In a shared interest QDRO, the alternate payee only receives a portion of each check when the participant spouse actually retires. For a younger spouse divorcing an older one, a shared interest order is a disaster, as their financial future is tied to the older spouse's decision to stop working. The historical shift in U.S. history has been toward the separate interest model, which provides true financial independence, but not all 401k plans support this feature. We are now entering the final, most critical phase of the 401k journey. We have analyzed the math, the tax traps, and the administrative hurdles. But there is one final variable that can destroy even the most perfectly drafted QDRO. It is the human element, the specific actions taken by the plan participant in the final days before the money moves. We are going to examine the controversial world of 401k sabotage, where participants attempt to intentionally trigger plan defaults or administrative freezes to prevent the transfer of funds. And finally, we will reveal the ultimate checklist for 2026 to ensure that when the dust settles, you are not the one left holding an empty digital folder. The end of the 401k era as we know it is here, and the rules for survival have never been more unforgiving. The phenomenon of 401k sabotage is the final, often invisible frontier of 21st century matrimonial warfare. As we reach the conclusion of this masterclass in 2026, we must address the desperate measures individuals take when they feel their financial fortress is under siege. Sabotage in this context is rarely about a single explosive event. It is a war of administrative attrition. Imagine a participant named Stephen who has been ordered to transfer $300,000 to his ex-wife Claire. Stephen knows he cannot stop the QDRO, but he can influence the state of the account during the administrative waiting period. Historically, one of the most common forms of sabotage involves the intentional mismanagement of investment allocations. In a standard 401k, the participant maintains the login credentials and the power to rebalance the portfolio until the very moment the plan administrator segregates the funds. If Stephen anticipates a market downturn or simply wants to minimize the amount Claire receives in a percentage-based split, he might move the entire account into high-volatility leveraged ETFs or extremely illiquid assets allowed under his plan's brokerage link. If the market swings wildly, he can claim it was merely a bad investment strategy. In 2026, courts are increasingly looking at historical trends of a participant's investment behavior. If Stephen was a conservative index fund investor for 20 years and suddenly became a day trader the month the divorce was filed, the court may find him liable for any losses incurred, treating the lost value as a distribution already received by him. Step by step, the prevention of this sabotage requires a proactive legal stance. The moment a divorce is filed, your legal team should request an immediate freeze on investment changes, or at the very least, a requirement for joint consent on any trades exceeding a certain percentage of the account value. Without this, you are effectively leaving your future in the hands of someone who may have every incentive to see that value diminish. Case studies from the mid-2020s show that participants who feel a sense of injustice often engage in what psychologists call financial scorched earth, where they would rather lose $1 themselves if it means their ex-spouse loses 50 cents. Another layer of sabotage involves the exploitation of the plan's hardship withdrawal rules. In 2026, the IRS has expanded the definitions of what constitutes a safe harbor hardship. Stephen might claim an imminent eviction or an urgent medical necessity to withdraw a significant portion of the 401k before the QDRO is served. While the plan administrator requires documentation, they are not a court of law. They often accept the participant's certifications at face value to avoid liability. By the time the QDRO arrives, the funds are gone, and the alternate payee is left to fight a legal battle for a share of a vanished asset. This is why the joinder process, which we discussed earlier, is the only way to legally bind the plan administrator to wait for the court's final word. Now let us move toward the ultimate 2026 survival checklist. This is the synthesis of everything we have covered in this deep dive. If you are navigating a 401k division today, your first step is the verification of the plan type. You must determine if you are dealing with a standard 401k, a 403b, a 457 or a TSP. Each requires a different legal instrument. Your second step is the acquisition of the summary plan description and the specific QDRO procedures for that employer. Many people waste months drafting a document that the plan was never going to accept because it didn't use their required internal codes. Your third step is the forensic look back. You must establish the premarital balance and account for any commingling. In 21st century U.S. history, the person with the better records usually wins the day. This means finding statements from 2010, 2015, and 2020 to trace the growth of separate property. Your fourth step is the tax-affected valuation. Never accept a dollar-for-dollar swap of a 401k for a house or a bank account without calculating the future tax liability. $100,000 in a traditional 401k is not the same as $100,000 in a Roth 401k or $100,000 in home equity. Your fifth step is the inclusion of the earnings and losses clause in your QDRO. This is the only way to protect yourself from market volatility during the months-long administrative process. Your sixth step is the designation of the surviving spouse. You must ensure that if the participant dies before the transfer is complete, you are still recognized as the beneficiary for the marital portion. Without this, the money could go to a sibling, a new partner, or even back into the plan's general fund depending on the employer's rules. Finally, your seventh step is the trustee-to-trustee transfer. When the money finally moves, it should never touch your personal checking account. It must go directly from the 401k into a properly established IRA in your name. Historical data suggests that the majority of tax penalties in 401k divorces occur at this final stage due to simple banking errors. In 2026, you should be present or on the phone with your financial advisor the day the transfer is initiated to ensure the coding is correct. The historical trajectory of the 401k in the United States is a story of increasing complexity and rising stakes. We have moved from a world of simple pensions to a world where every individual is their own pension fund manager. And in a divorce, that responsibility is doubled. The 401k is no longer just a savings account. It is a legal entity that requires a sophisticated defense. The potential outcomes of these cases define the quality of life for millions of Americans in their 60s, 70s, and 80s. When you look back at this era of U.S. history, the 401k divorce will be seen as the great wealth redistribution event of the middle class. As we conclude this part 10 of our masterclass, you now possess the technical framework to understand how these assets are truly valued, divided, and protected. But understanding the 401k is only half the battle. In the current economic landscape of 2026, there is another asset class that is growing even faster than retirement accounts, and it is almost entirely unregulated by ERISA. It is the world of executive stock options, restricted stock units, and phantom equity. These assets do not follow QDRO rules, they have different vesting cycles, and they are currently the number one way that high earners hide their true net worth during a marital split. If you think the 401k was complex, wait until you see how the legal system handles $1 million in unvested RSUs when the stock price is tied to a company's future IPO. The battle for the 401k is just the beginning of the financial deep dive. In our next series, we will peel back the layers of executive compensation and the hidden digital wallets that are redefining the American divorce. You have the map for the 401k. Now it is time to look at the assets the 401k was designed to hide. This concludes the 401k Deep Dive Masterclass. The future of your retirement depends on the precision of your next move.